Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Today we're going to talk about a case from Mississippi, the Mississippi Supreme Court, in fact, and we'll take a look at one of the more pressing problems across this country, which is governmental immunity. So this case arises out of a traffic accident that was a collision between a police officer responding to an emergency and a civilian. Now, you may recall a few months ago we looked at a case out of Connecticut where the Connecticut Supreme Court essentially took a much broader view of this immunity issue and said that the case could go forward. This case is substantially different than that. So the officer is driving to the scene of a rollover accident. And this rollover accident is one that, when you have a rollover, there's almost always going to be injuries. And so he's responding code through red lights and siren. And in spite of responding code 3 and seeing everybody else pull off the road for him so that he can go by, that's one of the things I think people ought to do automatically, but for some reason people don't always do it. One day it could be you in that rollover accident, so I always think it's a good idea to sort of store up that karma and pull over whenever you see a cop in an emergency. So the police officer is driving at his top speed was 92 miles an hour at one point. And as he comes up to an intersection, he's trying to move around one car, which did not get over, but stopped. And it stopped, of course, because it's stopping for a red light. The officer has a red light his way. And he's going at about 50 miles an hour when he gets to the intersection. He slows and he gets ready to go through the intersection. And this woman who says she didn't hear the sirens or see the lights until the impact is hit. And she and her daughter are taken to the hospital. They are released the same day. So we're not talking about a tragic accident here where someone's paralyzed for life. This is basically, you dented my car and you ruined my day. Be that as it may, they have every right to sue. They did sue, and the court in Mississippi, a case against a municipal police officer or any other law enforcement agency is handled under the Mississippi Governmental Tort Claims Act. And that Claims Act, or I guess you could call it that Immunity Act in some respects, the only time you can recover against an officer is when they exhibit basically reckless disregard for the life, health, and safety of other people. And what that means is you are aware of the danger, but you just disregard it. You just go right on, even though you're substantially certain that there's a high risk that somebody could be hurt. So here's what happened in this case. After the accident, the lawsuit gets filed, and this is tried to a circuit court judge. So the police officers come in and they testify. The chief of police says, look, under the circumstances, he was disciplined for not doing what he should have done in terms of clearing the intersection properly before proceeding. And he served a 3-day suspension, but under the totality of circumstances, he was not reckless. He was taking a measure of care for people because he had his siren on, he had his lights on, and he slowed down. And so the circuit judge found that there was no reckless disregard in this case. So one of the things that happens in almost every state, I don't know of a state where this doesn't happen, which is the person or entity that serves as the finder of fact. And of course, in a jury trial, a jury serves as the finder of fact. But in a bench tried case, which is what this case is, it's tried to a judge under the act. The judge sits as the finder of fact, and he's there to view the credibility of the witnesses. He makes credibility determinations. When there's two competing experts, he makes a decision as to which one is more credible, and that's his role. and that's only his role. The appellate courts do not get a right to superintend his judgment on the facts. So, in spite of that, the judge finds that there's no case here and does not allow the plaintiff to recover. They appeal, they take it up to the Court of Appeals, and in a very narrow majority, 5-4, with one judge not participating, the Court of Appeals reverses. And what it says is that we've reweighed the evidence and we find under the totality of the circumstances here that in this particular case there was reckless disregard. So the city of Oxford, which is the city that was affected by this ruling, the city of Oxford files an appeal with the Supreme Court of Mississippi. And the Mississippi Supreme Court makes the determination, and first of all, it spells out this rule with regard to how these things are supposed to be reviewed. Let's take a look at that. This is what the Supreme Court said about the standard of review. The standard of review we apply to a trial court's decision after a bench trial under the Tort Claims Act is well settled. A circuit court judge sitting as the trier of fact is given the same deference with regard to his fact-finding as a chancellor, and his findings are safe on appeal when they are supported by substantial, credible, and reliable evidence. We will not disturb a circuit court's fact findings after a bench trial unless they are manifestly wrong, clearly erroneous, or an erroneous legal standard was applied. A finding is clearly erroneous when, although there is evidence to support it, the reviewing court on the entire evidence is left with a definite and firm conviction that a mistake has been made. Moreover, the circuit court in its role as fact finder has the sole authority for assessing witness credibility. Importantly, while reasonable minds might differ on the conclusion of whether or not the officer in question acted in reckless disregard, it is beyond this court's power to disturb the findings of the trial judge if supported by substantial evidence. And in this particular case, they had testimony at the trial court from Oxford Police Chief Jeff McCutcheon, who testified as a non-retained expert that upon his review of the record and dash camera footage, Officer Brown's response was appropriate given the circumstances, which is odd given the fact that he disciplined him. But nonetheless, that was the decision that the trial court made. Okay, so as you can see, there is deference to the fact finder. In other words, the appellate court can't substitute its judgment as to the facts. The only thing it can substitute its judgment on is the law. And the only time they can the only time they can reverse a decision by a circuit court in these cases is when they are left with the firm conviction that something went terribly wrong. Basically, if reasonable minds could differ, then it's not an abuse of the court's discretion or an abuse of his role as fact finder. Let's take a look at that part of the opinion here. Reckless disregard. Under the Tort Claims Act, a governmental entity and its employees acting within the course and scope of their employment or duties shall not be liable for any claim unless the employee acted in reckless disregard of the safety and well-being of any person not engaged in criminal activity at the time of injury. So, they say we've recognized that the purpose of this law is to protect law enforcement personnel from lawsuits arising out of the performance of their duties in law enforcement with respect to the alleged victim. By requiring a finding of reckless disregard of the safety and well-being of others, the legislature set an extremely high bar for plaintiffs seeking to recover against a city for a police officer's conduct while engaged in the performance of his or her duties. And they go on to say, we've held reckless disregard as a higher standard than gross negligence and embraces willful and wanton conduct, which requires knowingly or intentionally doing a thing or a wrongful act. And then, reckless disregard is usually accompanied by a conscious indifference to the consequences, amounting almost to a willingness that harm should follow. Judicial precedent in Mississippi has long held that we look at the totality of circumstances when determining whether someone acted in reckless disregard, and essentially after reviewing all the facts, they said no. And then they look at a couple of other cases. In May, they said we held that the deputy sheriff's actions amounted to reckless disregard when he blindly backed out of a parking space and up an incline, which was also the entrance to the parking lot. And the facts of Brister and May are distinguishable from the case at hand, as they evince not only some appreciation of the unreasonable risk involved, but also a deliberate disregard of that risk and a high probability of the harm involved. So, the dash camera footage shows other motorists pulled over for Officer Brown as he approached them, proving he was observed as a result of his lights and sirens. Such actions cannot be characterized as reckless and indifferent to the safety of others. We emphasize that a trial judge's findings of fact following a bench trial are subject only to a limited scope of review if the trial judge applied the appropriate legal standard. It is the role of the trial judge, not the Supreme Court, to resolve conflicts in the evidence, evaluate the credibility of witnesses, and determine the weight of the evidence. Finally, the Supreme Court says, as we have stated, although reasonable minds might differ on the conclusion of whether or not the officer in question acted in reckless disregard, it is beyond this court's power to disturb the findings of the trial judge if supported by substantial evidence. And so as a result, they reverse the Court of Appeals and reinstate the trial court's judgment. Courts are frequently criticized for being an activist court, doing something that is effectively putting their personal spin on the law. And you'll see that applied to the Supreme Court. I think a lot of people thought that in the Dobbs ruling. I think a lot of people thought that in some of the earlier rulings from a more liberal court. I think that when a judge strays from the rules that are written down, they risk being called out for being somebody who doesn't follow the rules. And essentially, that's what the Supreme Court of Mississippi did here to the Court of Appeals. They said, look, you didn't apply the appropriate standard of review. You went far deeper than you were supposed to, and you substituted your judgment for that of the trial judge in an area where you can't do that. And I think the Mississippi Supreme Court got this right. I hate the idea that the lady doesn't recover for her damages. I don't know how serious they might have been. But the fact is, because I don't think tort immunity ought to be the rule of law. I think it ought to be that they're treated not a whole lot more different than anybody else. I think what you ought to do is have insurance, and that insurance ought to take care of claims that arise out of police officers doing their job. The Supreme Court followed the rules as had been laid down years before, and they reached the right result under their rules. So that's what I have for you today. If you have the opportunity today, go out of your way and do something nice for somebody. Be kind. You never know what kind of burden somebody else is carrying, and so sometimes it's a good idea to help them shoulder that burden with a smile. Have a terrific day, and I'll catch you down here at the beach next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.